This is Talking Law on Radio 97. If you have a question for Despina, she's happy to answer it for you. All you need to do is drop it in an email. Send it to breakfast97@superradionetwork.com.au. That is breakfast97@superradionetwork.com.au. And Despina, happy to answer those questions for you.
Now, for segment 2, we're talking to our friends in Queensland. So this is quite interesting. Obviously, the adjustments have been made to the REIQ contracts a couple of weeks ago. So we're still getting a handle on all the adjustments. So firstly, Despina, what or who, should I say, does this apply to? Is it just new home buyers?
Yes, so it applies to all sellers who are selling dwellings in Queensland. So we're talking about residential dwellings, we're talking about houses and units in the residential sector. So I thought we'd mention it because we have talked about the new REIQ changes in the past, the last few weeks, but we've really focused on this big controversial change, if I could call it, with the settlement date and the extensions now permitted under the new contract. But I don't think we've focused too much yet on the other changes that are important and significant for sellers, and that is the smoke alarms and the pool safety certificate requirements. So it's very, very important that we talk about it because they are important and they are significant. And the changes really means that there's more obligations on the seller. The seller has to have more knowledge about what they need to do prior to entering into a contract, because one of these, out of the two changes, one will now give a buyer a right to terminate the contract, and the other one will give the buyer a right to deduct monies at settlement now if the seller doesn't comply with their requirements under the new contract. So it's really important that we talk about this for sellers.
So starting off with smoke alarms, what's changed?
The changes are that you've got to put in a compliant smoke alarm. Now, when the previous contract, you've always had to tick whether the smoke alarm was compliant or not compliant, and there was legislation that was always in place where sellers had to comply. But now it's in the actual REIQ contract that the sellers must have and install the compliant smoke alarms by the settlement date. Otherwise, the buyer will be able to deduct a sum of 0.15% of the purchase price at settlement, meaning you calculate that sum and it gets deducted off the monies that the buyer owes the seller at settlement. So unless the seller complies with their requirement now under the contract, this is what the buyer can do. Now, the questions we've had recently asked of us by clients and sellers is, well, what type of smoke alarm are we talking about? I don't understand. Where do I find this information, which is really critical? So I thought I'd give the website because we're obviously not experts in that area, but what I can do is say, look, here is the website. Go to the website and then talk to an expert in this area who will be able to come and install it for you so you are compliant, because nobody wants monies deducted at settlement if you could simply deal with the issue and make sure they're compliant. I mean, obviously there will be a cost for sellers to perhaps make sure that the smoke alarms are compliant and they're properly installed. But perhaps I would suspect that will be a lot less than a 0.15% deduction of the purchase price. Yeah. So the website is qfes.qld.gov.au/smoke alarms.
Easy peasy. Look at that.
Easy peasy, yeah. So if you go to that website, you'll be able to tell you what type of smoke alarm. But then again, if you want to just engage a consultant, and there's plenty of them, I'm sure out there, they can just come and advise you about what type of smoke alarm you need. So that's really, really important. And the other thing I'll say is with this is when you're selling property and you're negotiating terms, sellers might want to think that if they're selling a site that's going to be demolished or that's going to be redeveloped, you might want to consider actually removing this term in the contract, because why would you want to install
brand new smoke alarms
when it's going to be developed and no one's going to occupy it? So that's why sellers need to have this knowledge in the background when they are selling property. They need to know about it. They need to comply with this prior to settlement. If it's a development property that's going to be demolished anyway, take it out. So that's smoke alarms. So the penalties for sellers if you don't comply is that deduction of 0.15% of the purchase price, no right of termination. But then we compare it with the pool safety certificate requirements now under the contract where there is a right of termination for buyers. So really important for sellers to understand what this means for them. So the new provisions are that the seller has to give a current pool safety compliance certificate to the buyer at settlement. So that's the first thing I'll say. The exception to that, of course, is if the seller's already done that. And typically those certificates are attached to the contract when you sign them. So the buyer can see, okay, there's a compliant pool safety certificate that's current at the time they sign the contract. Happy days, everyone's, complied. Or if the seller doesn't have a current pool safety compliance certificate, they can give the buyer what's called a Form 36, notice of no pool safety compliance certificate. But the difference here is that now if the seller has that certificate or doesn't have a compliance certificate but wants to give this other notice to say, look, I don't have a compliance certificate, he has to do that now prior to the buyer signing the contract, so prior to entering into the contract.
Yep.
So the timing of this is critical. So if the seller wants to take advantage of that, they've got to do it before the parties sign. Otherwise, he's lost that opportunity and the seller must organise a pool safety certificate, compliance certificate by settlement. And the big deal here is that if the seller doesn't do it, the buyer can terminate right up until the day of settlement on the morning because it's a requirement to hand it over at settlement. Yep. So if you don't do that, if you don't comply, the buyer can terminate.
Yeah, obviously very important. Just briefly, Despina, how long are those certificates current for?
Oh, I believe they're current for 1 year, typically.
Yep.
So when they issue, yes, they're usually for 12 months. So before, people used to hand in that notice of no pool safety compliance after the contract. So the critical thing is you've got to do it before the contract. So even when you're starting to market, talk to the agent. You need to say, look, I've got a current pool safety certificate. It's all good. We're going to attach it to the contract. No problem. Or I actually don't. So what are you going to do about it? You're going to get it done before settlement and incur the cost, or you're going to get that notice of no pool safety compliance certificate and make sure the agent gives it to the buyer before they sign a contract.
For sure. That is Despina Priala there from Priala Legal. Great advice as always. And if people want to get in touch with you directly, Despina, where can they go?
They can ring the office 55291 294, or they could text my mobile 0400141269. And they can also go onto YouTube to look out for all of our segments that we've had on air and our website.
Fabulous. And you can also send your questions to us here at breakfast 97 at superradionetwork.com.au. Thank you so much again, Despina. We'll talk to you again next
week.
See you then.